This video will walk you through how a victim of a sexual offense, stalking, or cyber harassment can get a temporary protective order. The only place you can get a temporary protective order is from the family part of the county courthouse. They are granted from 8:30 a.m. until 4 p.m. The police cannot help you apply for a temporary protective order. A victim can contact the court in the county where they live, or where they went for safety, where the offender lives, or where the offense happened. Victims can go to the court in person, call, or submit an application online. The court will need identifying information for both the victim and the offender. The victim will have to describe the most recent offense, either one of the 3 sexual offenses, stalking, or cyber harassment, and whether there is prior abuse. A hearing officer or judge will review the paperwork, listen to the victim, and determine if there is good cause to issue the protective order. If the temporary protective order is denied by a hearing officer, the victim can ask to appeal that decision to a judge. The victim should do that right away, and the appeal will be heard the same day. If the court approves the temporary protective order, the victim will receive a copy of the order. Then it is the court's job to make sure the offender knows about it as well. They will make sure the offender is given the order personally, either by the police or a sheriff's officer. The victim's address will not appear on that order. The victim will never be asked to give a copy of that order to the offender. Also, the victim should be told when the offender is served with the temporary protective order. After the protective order is served, the victim should report any contact from the offender to the police as a violation of that order. With the temporary protective order, the victim will receive a court date for a final hearing. The final hearing will be scheduled approximately 10 days from the date the temporary protective order was entered and will be held at the county courthouse where the order was entered. The purpose of this hearing is to decide if a final protective order will enter or if the temporary protective order will be dismissed. In order to make this decision, the judge has to decide if the victim proved their case. First, the judge has to determine if one of the offenses occurred. If the judge determines it did, they will consider the chance of future risk to the safety or well-being of the victim. The standard by which the judge decides those factors is what we call preponderance of the evidence. This means that the victim's version of events has to be more credible than the offender's version of events. The victim has to tip the scales in their favor. If the judge finds that the victim has proven one of the offenses and that there is future risk, then a final protective order should be granted. Legal Services encourages victims to seek legal advice regarding their specific situation if possible. To speak with an attorney at Legal Services of New Jersey, you can complete an online intake at lsnjlawhotline.org or by calling 1-888-LSNJ-LAW. To get the fullest sense of a victim's rights in this area, view all 3 videos in this series. Victims of sexual offenses can also reach out to their local sexual assault agency. The list of agencies can be found at the website for the New Jersey Coalition Against Sexual Assault, or njcasa.org. Victims can also reach out to the New Jersey Coalition to End Domestic Violence at njcedv.org.